Now, so often you hear with the people who are against Edward Snowden and say that the NSA spying is no big deal. Now, of course, they'll say both things at the same time. Oh, Snowden is dangerous, a terrorist, a state traitor, treason, terrible, imprison him forever. And at the same time, oh, look away from what he revealed. It's totally irrelevant. Well, now, wait a minute. Which one is it, right? Well, when they say it's irrelevant, they largely talk about how it's perfectly legal anyway. It's perfectly legal. Well, that's, of course, not entirely true, and we've been telling you that for a long time. Now, a great article written by Jennifer Stiza-Granick, who's the director of civil liberties at the Stanford Center for Internet and Society, and also Christopher John Sprigman, who's a professor at the University of Virginia Law School. And they wrote it in the New York Times, and they explained that the NSA program is, in fact, totally illegal. So here's how they explained it. They say the two programs, referring to the phone metadata program and the PRISM Internet program, violate both the letter and the spirit of federal law. No statute explicitly authorizes mass surveillance. It's just not the case. Now, when you talk about the phones, they use Section 215 of the Patriot Act. And here, the two professors explain, no, that's not what Section 215 says. Let me quote them. The law under which the government collected this data, Section 215 of the Patriot Act, allows the FBI to obtain court orders demanding that a person or company produce tangible things upon showing reasonable grounds that the things sought are relevant to an authorized foreign intelligence investigation. So you can't just say, hey, you know what? Give me all of the phone metadata. It has to be relevant to an investigation, and it has to be seeking tangible things. It clearly is not. They're absolutely right about that. They go on to explain. They say even in the fearful time when the Patriot Act was enacted in October of 2001, lawmakers never contemplated that Section 215 would be used for phone metadata or for mass surveillance of any sort. Now that's clear on its face, but in case you weren't clear enough on it, they go to Jim Sensenbrenner, who was the author of the Patriot Act. He now says, and he's no civil libertarian, Republican from Wisconsin, very deep Republican, very proud of passing the Patriot Act. But he says, quote, wait, how can every call every American makes or receives be relevant to a specific investigation? And that's, of course, exactly what Section 215 demands, that it be relevant to a specific investigation. And Congressman Sensenbrenner is right. It can't possibly be relevant to a specific investigation. In other words, the program is illegal. It is not within the law. It is not within the Patriot Act. And the author of the Patriot Act agrees. The professors continue. The government claims that under Section 215 it may seize all of our phone call information now because it might conceivably be relevant to an investigation at some later date. Well, what an absurd standard. Can you imagine? I'm going to collect every piece of information in case at a later time I determine you to be a criminal, and I want to go back and the stuff that was not relevant before while I was collecting it, ex post facto becomes relevant. Well, under that definition, everything that is ever done is relevant to a possible future investigation of you. Welcome to 1984, by the way. So, if you take that as the plain meaning of Section 215 of the Patriot Act, you're being ridiculous. Of course that's not what they meant, and they say that's not what they meant. It's absurd, it's totally illegal, and it is done, that absurd interpretation is done to justify their law breaking. Continuing, the government may not intentionally acquire any communication as to which the sender and all intended recipients are known at the time of the acquisition to be located in the United States. Now, that is the second part of this. They're saying, wait a minute, now on the internet PRISM one, you're saying, okay, it's all authorized because of a different provision, and that's the FISA Amendments Act of 2008, Section 1881A. But under that act, as we just read, you must not collect information if you know if it's an American's information. Well, they explain here the government's excuse. The government knows that it regularly obtains Americans' protected communications. The Washington Post reported that PRISM is designed to produce at least 51% confidence in a target's foreignness. By turning a blind eye to the fact that 49+% of the communications might be purely among Americans, the NSA has intentionally acquired information it is not allowed to have. In other words, point 2 as to why the program is clearly illegal. They know that 49% of the time they get information they're not supposed to have. They know that. And they know that that's against the law. Now, who cares? That's my twisted interpretation. Well, I can interpret any law. Well, I mean, you say I'm not allowed to rob a bank, but I mean, what does robbery mean? And what does a bank mean? Look, in the future, that money is mine. So I'm not really robbing it. I'm just claiming money I'll have in the future. Anybody can play these games. These laws are unconstitutional and illegal. Speaking of unconstitutional, the professors go back to something that I've been saying from day one. Has anybody read the Fourth Amendment? So they explain here. The Fourth Amendment obliges the government to demonstrate probable cause before conducting invasive surveillance. There is simply no precedent under the Constitution for the government seizing such vast amounts of revealing data on innocent American communications. In fact, they say, when it talks about the Fourth Amendment protections that we have under the Constitution, the government has, quote, made a mockery of that protection. And they're absolutely right about that. What's interesting is, by the way, the Supreme Court in the United States versus Jones, even Sam Alito, deeply right-wing conservative Sam Alito, said, hey, the government can't even collect all of your public information that's already public, not even private, if they're trying to collect it to gather evidence about you when they don't have probable cause and they don't suspect you of a crime. That's Big Brother. And he's saying that's unconstitutional. This, under that standard, this is massively unconstitutional. And here's two law professors from Stanford and University of Virginia, two great law schools, pointing out the obvious. Just read the Fourth Amendment. Apparently the Supreme Court has, but the Obama administration and the Bush administration did not. And finally, they conclude the article by saying, it's time to call the NSA's mass surveillance programs what they are: criminal. Now, that's the final point I want to emphasize. As we do an international manhunt of Edward Snowden, because he's a criminal, it turns out the real criminals are back here at home. They're the ones that did massive violations of the law. So anytime they say, well, we got to go get Snowden, we have to go get him because he broke the law. Refer them to this article in the New York Times. Who really broke the law? It was the government that broke the law. You want to put Snowden in jail? Well, put Barack Obama and George W. Bush right next to him, because they clearly broke the law, and anyone who has read these laws can honestly interpret them, and the Fourth Amendment knows that these programs are both illegal and unconstitutional. You want to put Snowden in jail? Go in the cell right next to him.